Were late fees subtracted out for the payments made into court escrow?
She was late every time it was paid before.
Why can't I just get an answer to my question?
They would send you the bill anyway. You could always go online. You can look it up.
I just was concerned. That's all, sir.
But why was it important for you to change the name?
I thought I needed to be responsible for it. That's all. I just wanted to make sure I got it.
You're the homeowner.
This case opens exactly the way high-conflict landlord-tenant disputes usually do. Not with a dramatic accusation, but with a deceptively simple accounting question that ends up exposing everything underneath. Late fees, escrow, credits, numbers that don't line up. And when Judge Simpson asks this question, he's not just asking for a yes or no. He's signaling that the court is about to peel back layers of financial confusion, miscommunication, and potentially improper conduct. At its core, this is a non-payment of rent case. But as you'll see, it quickly morphs into something much bigger. Questions about harassment, interference with quiet enjoyment, mishandling of escrow funds, and whether a landlord can simply invent their own rules when rent is paid through the court. The tension here isn't just about money, it's about control, credibility, and accountability. Pay attention to how the parties answer questions versus how Judge Simpson frames them. He is methodical, skeptical, and very focused on structure, leases, statutes, escrow rules. That's important because Michigan landlord-tenant law is rigid in some areas and unforgiving when those rules are ignored. As we move forward, ask yourself, is this really about unpaid rent, or is this a power struggle that spiraled out of control? And more importantly, who actually kept the better records here?
Calls the case of Anderson versus Lyman. Both matters being called.
I apologize for that interruption.
Not a problem. State your appearance, please.
Good morning, Edward Mall, MAHL P27115 attorney for the plaintiff.
All right, where are we on these cases?
Good morning, Judge. My furnace had went out this morning. Not only did my furnace go out, Lori showed up to my house last month and had some guy walk around the back. But when he saw the camera, he ended up leaving.
What?
When the guy she had moved to the house saw the camera, he ended up leaving. And she's still sending falsified information about the case to the water,
To who?
the water department.
So somebody last week showed up to your house?
No, that's a video of him walking around the house.
Did you send somebody to the premises?
No, I certainly did not.
She was in the car. You can see
Send
it in
it.
the
He
video.
was what?
She was in the car. You can see it in the video.
And Ms. Anderson, you're indicating you didn't send anybody? So she had a video of that? That would,
I didn't send anybody to the house.
were you at the house? Were you in a car near the house?
And about a month and a half ago, I think I drove by one time. I didn't drive to the house. I think I just.
Was the car sitting there, ma'am?
Yeah, the car was sitting out front.
No.
And they pulled up a little bit.
Out front of
The
the
house. They tried to get out the view of the camera. And then he proceeded to look at the camera. And then he walked around the house and he seen the camera and then he went back to the car and they pulled up. So he didn't finish walking around the house because he seen the camera.
You have that video
Yes, it's in my camera roll.
on your phone?
Yes.
Did you bring your phone in?
Yes.
Okay. Can you send it to the court if I gave you an email?
Yes.
You know how to do that? And also you might need to send a copy to. These are all non-payment of rent cases.
Judge Simpson makes an important move here. He narrows the scope. Despite all the side issues bubbling up, the court is slimming this down to what it legally is, a non-payment of rent case. That matters because courts do not allow parties to muddy the waters indefinitely. At some point, everything has to come back to rent owed versus rent paid. Escrow is a critical concept here. When tenants pay rent into court escrow, that money is protected, documented, and governed by specific rules. Landlords don't get to treat escrow payments as late in the traditional sense, nor do they get to pile on fees simply because they dislike the method of payment. This is where many landlords make costly mistakes, assuming escrow payments are optional or inferior. They're not. They are court-recognized payments, and mishandling them can backfire badly. Judge Simpson's tone suggests he's already alert to that possibility. Audience question: should paying into escrow protect a tenant from late fees automatically, or should landlords still have leverage? Where do you think the law should draw that line?
Both of these.
There's a lot of issues, but we're slimming it down to non-payment of rent this morning.
Well, from plaintiff's position, what is plaintiff's claim in, I guess, either one of these cases?
Well, at this point, we are concentrating on rent. There's been only, how many months? 2 months paid? Only 2 months of rent paid.
So how much are you claiming is owed? How much do you have in escrow there?
This includes water, because there's $1,900, more than $1,900 due for water bill for water that's left on. The balance is $15,899.39.
15,000.
$899.39. That gives her credit for the escrow that's with the court of $6,600. 2 payments of escrow have been made only.
She's claiming over 21,000, Owen?
Now we enter the numbers, and this is where credibility starts to live or die. Multiple totals are being thrown around: $15,899, $21,000, $22,499. When numbers shift this much in court, judges get suspicious, not because mistakes never happen, but because accurate accounting is the landlord's responsibility. Judge Simpson is clearly trying to reconcile rent, escrow credits, and water charges into a coherent picture. The problem? The picture keeps changing. That's dangerous for the plaintiff. Courts expect landlords to arrive with a clean ledger that clearly shows charges, credits, dates, and balances. Anything less invites scrutiny. Water bills complicate things further. Utilities may be owed, but they must be clearly supported by documentation and consistent billing practices. You can't simply lump them into rent without explanation, and you definitely can't inflate totals without airtight proof. This raises an important viewer question. When a landlord's numbers keep changing, does that suggest confusion or something worse?
Yeah, she figures $22,499.39 is the balance. When I say she, I mean Miss Anderson.
And how much did you say?
66.
Servants. Let's take a look.
Okay, I know that. I know that.
So what months is she claiming rent for?
All the months after, well, she has not paid anything since the first the 2 months, May and June. She owes the rent from
So
July.
you're claiming for July?
Yes. August, September, October, November, and December. Not, yes. Okay, don't. Into the court.
You paid
I know,
what?
we know that.
Paid those months.
Where?
Talking about July and all that, I paid that.
Yeah, July and August have been paid. They're escrow. They're in escrow now. September, October, November, and December.
Just a second, counsel. So you're looking at 6 months, basically, right?
Yes, 6 months have not been paid to us. 2 months have been paid into the court. So this is 4 months owed.
3,300. So, Ms. Lyman, I'm a bit confused because when we appeared here before, you had indicated that you were going to pay the rent into court escrow, and I don't have anything. I only have 2 months in escrow. How much did you pay in escrow this morning?
I paid that $22.70 that I said I was going to pay.
$22.70.
Yes.
What's this?
Water either, mention water.
That's still, but that's not, your monthly rent is 33.
Yes. Remember when I told you how I broke it down for the prorated amount? And that's what I came out to when we were here last time.
Okay, but if that paid, so here's my question. If I have in escrow July, we'll just call it July and August because those are the latest ones.
And I paid September this morning.
Okay. And then if that's well, that's the 2270.
Mhm.
Yes, all right. So without going into even at this point, the difference between the two.
I'm only 2 months behind.
This is a classic courtroom disconnect. From the tenant's perspective, escrow payments plus partial payments equal being only 2 months behind. From the court's perspective, unpaid months are unpaid months, intentions aside. Judge Simpson immediately challenges that framing because courts deal in recorded payments, not personal accounting systems. This moment highlights how easily tenants can misunderstand escrow mechanics. Paying into escrow does not reduce the monthly rent owed unless it fully satisfies that month. Partial payments simply create partial credits. It's also where patience starts to thin. You can hear Judge Simpson pressing for clarity, not because he's unsympathetic, but because the math must settle before anything else can be decided. Without clear math, no ruling is possible. Viewer engagement question. If you were in this position, would you rely on your own calculations, or would you insist on a written ledger from day one?
Okay,
Well-
but where is the 2 months?
I don't have it right now. I was planning on paying at the end of the month.
I don't see how the 2270 pays at September either. And she's prorated it, but prorated, what does it mean? It's prorated. The entire amount is owed.
I didn't get it already.
I understand that, counsel. What did I just say? So you don't have October, November, or December at this point.
The rest I was planning to pay at the end of this month.
What do you mean?
Like to pay the rest off at the end of this month.
So basically 9,900?
No, it should only been about 7,000.
Why would it be 7,000? Your monthly rent is 3,300.
Yes, only these couple months. I thought it should have been 7,650. I thought that was all.
Mm-mm.
You know, we've got a copy
There's
of,
6 months that's owed. Okay, I have 2 months in escrow. Right? So now I'm dealing with basically 4 months. You paid 2270. Again, I'm not going to get into necessarily why you got to that figure. I'll deal with that. I know what I have. But then when I look at October, November, and December, I have nothing.
Yes, because I didn't pay October, November, then we're just getting to December.
Well, okay. So you're the two, at this point though, there's 9,900 that's owed at a minimum into court escrow. Right? What you say?
I suppose so, yes. Because I'm confused because I paid her May and I paid June when we first started.
The only thing I'm looking at right now is July through December. I'm looking at those 6 months. And if I'm looking at those 6 months, I have 2 and a partial.
Partial is in September.
Yeah. The 2270 that you paid today, basically a partial for September. Follow me?
Yes, I get what she's saying. I thought when I had mentioned the overpaid amount that I paid in June and the extra $300 and how much it would have been 533 to be prorated. That's how I came up with that 2267. Because I only owe 3 months of rent, including December. That's,
I don't know where this proration you have is coming from, where you're taking monies off for September.
because in May, I didn't get prorated at all in May.
Pardon?
I didn't get prorated at all in May when I moved.
When you moved in,
Yes,
you moved in on what day?
on the 5th.
But your lease started what day?
Which started on the 5th.
On the 5th. And runs through what?
The 5th of next September. I don't really think it.
I have a copy of the lease, Your Honor. It starts May 5, 2025. It ends May 4, 2027,
May 4th.
of 2027. I have a copy of the, you got it, okay.
So you follow that, ma'am?
Yes.
So there would not be a proration.
This is a textbook legal clarification, and Judge Simpson explains it carefully. Because the lease runs from the 5th to the 4th, not the calendar month, there is no proration. The tenant gets the full rental period, just not aligned to the calendar. This matters because proration arguments often sound fair emotionally but fail legally. The lease controls. And here, the lease clearly anticipates the offset days at the end, eliminating any entitlement to partial rent credits. Judges appreciate when leases are clear, and they enforce them strictly. This explanation undercuts a major defense argument and recenters the case on full monthly rent obligations. Viewer question: should leases like this be explained more clearly to tenants up front, or is it the tenant's responsibility to fully understand the contract they sign?
How come?
Because you would have 4 days, in essence, at the end of your lease. If your lease ended on the 30th or 31st of a month, I could see and get your argument about the 5 days because you didn't live there those first 5 days. But the way your lease runs, it runs from the 5th, but ends on the 4th of whatever month. So you get all your time. It's just not on the calendar month, basically.
I would remind the defendant that she's ignoring the water bill that's $1,900.
Why are you dealing with that right now? Did I ask you about it?
I brought it up
Did
because
you
she's
need
not,
to remind her of it?
just a reminder of it, yes.
Why?
She's not
I'm
talking.
trying to deal with something right now.
Okay, I'm sorry.
You follow that, Ms. Lyman?
Yes.
So give me a total of 66 plus 2270. 8,870. All right. Yes, ma'am.
I can pay the 533 today for the 5 days.
Say again.
The 533, I can pay that today for the 5 days.
So basically, you can make September whole.
Yes.
At this point, Judge Simpson confirms September can be cured, but immediately pivots to the real problem: October, November, and December. This is the heart of the case. 1 month fixed doesn't erase 3 missing ones. You can hear the judge's frustration, not at the tenant, but at the cycle of partial explanations. Courts need finality. They need clean answers. And they need parties to confront the full scope of the obligation, not just the pieces that feel manageable. This exchange sets the stage for what's coming later: scrutiny of late fees, water charges, and ultimately, whether the landlord's conduct undermined her own claim. The court is not done asking questions, and neither should we be done paying attention. Engagement question: at this stage, who do you think has the stronger position? The landlord with unpaid months or the tenant pointing to escrow and interference?
All right. But what about the other 3 months and why aren't those paid into court escrow?
I got behind, a lot of family stuff had happened, so I had got behind. My plan was to pay those at the end of this month. Into this.
Are you still up?
It says it's still. Cause I paid a.
Hold on a second. That shouldn't have happened. Are you sure? We're still going. Say again?
No, because I was talking about the extra 200 that I paid in June and plus the 300 I was supposed to be getting back, that 532. The $300 from the deposit.
For what?
When I overpaid in June, I paid $200 in June and then the $300 from the deposit that I was supposed to get back.
The 300 from the cleaning deposit?
No,
Or
it was for
the what?
moving in.
Your Honor, if I could explain, there was a security deposit. It was determined by the plaintiff that the security deposit was $300 too much based on the guidelines in this state of Michigan statutes. So she gave her a $300 credit, and it's shown on this ledger.
This exchange is where accounting errors begin to look less like confusion and more like risk. Judge Simpson zeroes in on the security deposit because, under Michigan law, security deposits are not casual funds. They must be tracked precisely, credited correctly, and, most importantly, held separately. The landlord's position is that the $300 overpayment was credited on account, not to a specific month. The tenant, understandably, is confused. From the court's perspective, that confusion is a problem created by the landlord's bookkeeping, not the tenant's misunderstanding. Courts expect landlords to know exactly when credits are applied and to communicate that clearly. This matters because credits affect notices, totals, and the legitimacy of the claim itself. If a notice overstates what's owed, even by $100, it can undermine the entire filing. Judges do not gloss over that. Audience question: should a tenant have to discover credits by interrogating a ledger in court, or should landlords be required to proactively disclose them?
For June.
What's shown on the ledger for the total balance? It's from the balance. The balance, it's part of the number that
But
is
what
taken
month
into
does she
account.
get the credit for? Because
It's not for a particular month. It's just on account. She's saying it's for a particular month. We're saying it's on account.
well, it's got to be for a particular. It's when was the security paid?
May security, but it was paid in May.
So if she overpaid the security, that means it's credited toward May rent. Gotta be.
All right, then we've credited it to her on the account, whether it's whatever month it's applied for. She's gotten that credit. It's shown on this ledger.
When did I get the credit? Because nobody told me. He just told that she was supposed to give me the $300 back.
Say,
In June, I overpaid $200 as well.
I get what you're saying, that there was an overpayment in June. But how much did she pay in June? Just
30, she paid $3,300 in June.
3,300?
The rent, and she paid her late fee for June.
Oh, late fee. Okay.
How much is the late fee?
At the time she paid,
How much is the late fee?
the late fee is $150, but I think she may have paid $250. I don't have those records with me. She just put it in my account automatically. She just,
Council has a ledger sheet in front of it. Does that ledger sheet reflect that overpay?
It doesn't. It reflects a charge of $150 for a late fee.
This is a dangerous moment for the plaintiff. When Judge Simpson asks whether the ledger reflects an overpayment and the answer is no, alarms go off. A ledger is supposed to be the authoritative record. If it omits known payments, it's incomplete, and incomplete records weaken claims. The explanation that the ledger only starts in July doesn't help. Judges expect continuity. You don't get to reset accounting history simply because rent problems began later. If a tenant paid money in May or June, That money exists in the accounting universe, whether or not it's convenient to show it. This exchange exposes a fundamental flaw. The landlord did not maintain a running ledger. Instead, records were created reactively after disputes arose. Courts view that as sloppy at best and suspect it worst. Think about this. If you were the judge, would you trust totals built on partial records, or would you start discounting claims that rely on them?
But she said she paid 200 and
Yeah.
something.
Yeah.
Oh.
She directly deposited the funds into my checking account. She didn't give me in, she put an extra $250 in the account for June. She directly deposited into my account.
Okay, I don't care how it got there. Is the ledger sheet that council has, does it reflect that that payment was made?
No, because the ledger sheet was just from July forward.
Why isn't there a ledger back to the beginning of her tenancy? Or if it's just from July forward, why doesn't it reflect? Does it give a credit at the beginning?
She's entitled to a credit of $100 for June.
If I paid,
How do I get $100 when that's not what Ms. Anderson just said?
She paid $250 for a late charge. Is that what? Okay, she should have paid $150. So
She didn't give.
Okay, does the ledger that I have, that you have, counsel, does it reflect that credit?
no,
Why not?
my client compiled this from the date at which the date at which the rent was not paid. So
So there isn't a concurrent ledger that's kept?
Well, last time we were
Something
here,
that was made up afterwards?
go ahead and explain when you prepared this one.
I prepared this ledger for, I didn't know I was supposed to prepare it for the previous month. I just prepared it for July.
Why doesn't her account have a ledger?
Judge Simpson asks the question that hangs over the entire case. Why isn't there a complete ledger? This isn't a trick question. It's foundational. Landlords are running a business, and business requires records. The responses that follow only deepen the problem. The ledger was created only after non-payment began. Prior months weren't tracked. Credits were applied loosely. From a legal standpoint, that's unacceptable. Courts rely on documentation, not reconstruction. This moment is also about fairness. Tenants should not have to reverse engineer their own payment history in open court to prove they paid money that the landlord admits receiving. That flips the burden improperly. Engagement question. Should courts impose penalties when landlords fail to keep proper ledgers, even if some rent is truly owed?
Why isn't there a ledger that reflects payments on this tenancy? What was the answer to that?
I just didn't prepare a ledger before. I didn't know I was supposed to prepare a ledger before for escrow.
So how do I find out what she paid in May?
Because
How do I find out what she paid in May?
I can compare what ledger for those are.
But where is that coming from? I don't,
Your bank account show the payments that you received.
Yes, my bank account shows it.
so. And so if that ledger starts out in July, this one that's been created, it doesn't show a credit.
For the $300 overpayment for the
June.
security deposit and the $100 overpayment for the So we need.
But you're joking.
So I guess what I'm saying is, why come July, if that ledger's to be believed, do I not have a $400 credit, which means that for July, she should have only paid 19 or 2,900?
We have a $300 credit on the ledger. We just are missing the $100 credit.
This acknowledgement is small in dollars, but huge legally. A missing $100 credit means the opening balance was wrong. And if the opening balance was wrong, every subsequent calculation based on it becomes questionable. Judge Simpson walks through the logic carefully. If credits existed, July's balance should have been lower. That affects whether notices were accurate and whether the amount claimed is legally enforceable. This is why judges obsess over details. Landlord-tenant law doesn't tolerate rounding errors or close enough math. Accuracy is the standard. Viewer question: if the court finds even minor accounting errors, should it reduce confidence in the entire claim or isolate and correct them?
Call this
So we're missing the $100.
No. You have it at some point on that ledger, right? But if you created a ledger that accurately reflects this tenancy, that means her opening balance that she would have owed as of July 1 would have been $2,900.
Yeah, but yeah. So I can.
And so, counsel, the 19, no, the amount you gave me of the 22,499.39, I think it is. Did that reflect $100?
No, I did not know about that. So it's 22,399.39 minus the escrow.
How much did she pay in security deposit?
The 525 plus the 750.
And where is that being held?
In my name.
In what?
In my name.
Is it in a separate account?
Yeah. Can I explain something?
No, answer my question.
Yeah. Yes. Yes.
Or is it being held was the question.
Oh, Chase Bank.
In a separate account.
Since then I've moved.
Is it in a separate account?
This is one of the most serious moments of the case. Judge Simpson is no longer talking about math. He's talking about statutory compliance. Michigan law requires security deposits to be held in a separate account, not commingled with personal funds. The landlord's answers are hesitant and inconsistent. The account changed. The tenant wasn't notified. Eventually, it becomes clear the funds were commingled. That's not a technical mistake. That's a legal violation. Judges treat this seriously because security deposits are tenant money, held in trust. When landlords blur that line, courts see it as misuse of funds. Even if no money was spent, the violation exists the moment commingling occurs. Ask yourself, should a landlord who violates deposit laws still be trusted to enforce strict rent compliance?
Has it been in a separate account from the beginning?
No, because I actually moved everything over to LMC.
I don't know where her security deposit is.
You said it's a Chase or it's been moved to
I actually closed the Chase account down, and it's my LMC account.
what is LMC?
It's a like Michigan credit. It's just I was getting charged too much.
Okay, just tell the judge where it is. What bank is it?
LMC.
What is LMC?
It's like Michigan
Did you notify the tenant that that's where the security is being held?
No, because no, sir.
Is it in a separate account at this new institution?
No, sir.
It's just commingled with your account?
It's actually the savings account, so I don't.
Is it commingled with your savings account?
No, I have a separate savings account and I have a separate checking account.
I'll try the question again.
Is it in a separate account that delineates it as a security? So it's in your savings or checking account?
Yes.
It's commingled with your funds?
Yeah, but I don't spend it.
It's commingled with your funds?
Yes.
Once the landlord admits the security deposit is commingled, the legal landscape shifts. This isn't speculation anymore. It's an on-the-record admission. Judge Simpson doesn't need to lecture here. The statute speaks for itself. This admission doesn't automatically erase rent owed, but it absolutely affects credibility and remedies. Courts can offset damages, reduce judgments, or award tenant claims when landlords mishandle deposits. What's striking is how calm the judge remains. He's collecting facts, building a record, and preparing to weigh consequences later. This is how experienced judges operate. They don't react emotionally. They react structurally. Audience engagement. If you were the tenant, would this admission change how confident you feel walking out of this courtroom?
Did you send that?
Yeah, I sent it.
Who'd you send it to?
I sent it to the district court.
Oh. They gotta pull it for me. That's all right. We're good here.
Oh,
Well, tell Ann, please. So, Ms. Lyman, how much are you counterclaiming for?
These have
Half of what?
escrow amounts that I paid in escrow.
I'm sorry?
At least half of the amounts that I have paid in escrow.
All right, and on what basis are you claiming that money should be paid to you?
The counterclaim now comes into focus: interference with quiet enjoyment. This is not about rent, it's about conduct. The tenant alleges harassment, emotional distress, and repeated disruptions. Judge Simpson immediately narrows the claim. Emotional distress alone isn't enough in a contract case, but interference? That's viable. If a landlord's actions made the tenant's occupancy unstable or intimidating, damages can be awarded. This is where earlier testimony about people at the house, inspections, and the water bill begin to matter. Patterns matter more than single events. Viewer question: where should courts draw the line between legitimate property management and unlawful interference?
What do you mean by that? Like, why?
Meaning, why should I give that to you?
Because I haven't been able to live peaceful.
So interference with your,
My peace,
all right.
my mental,
Any other reason?
mentally, emotionally, just the stress.
All right, but this is a contractual case, so some of those damages aren't there. But you're basically claiming an interference with quiet, useful enjoyment of the premises.
Yeah.
All right. And how much is the plaintiff claiming in additional water?
The water bill is 19, this is just for May 5th to December 8th, is 1915.80.
1915,
Yep, 80.
80?
In the water bill, I had a payment plan. I had a plan figured out. And when I called, they said she called and took the water out my name, put it in hers and paid it. And then I sent the
Did
email
you
about
do that?
what happened was.
No. Did
Yes,
you do
yes,
that?
because he said it would go to my tax bill, but she didn't accept the plan by that date, the 13th of October, which she did not. I have the manager of the utility company said she did not do that, and so I came in personally and set it up and paid it with borrowed funds, so that it wouldn't go.
I don't care where the funds came from, you paid it.
Yes, so
The water bill issue crystallizes here. The landlord paid it using borrowed funds and wants reimbursement. The tenant doesn't dispute the amount, only the method and timing. Judge Simpson's approach is pragmatic. If the tenant owed the bill, payment had to happen. The dispute isn't about whether it was owed, but whether the landlord's actions interfered with the tenant's ability to manage it herself. This distinction becomes critical later when damages are considered. Paying a bill doesn't justify harassment or unilateral changes that disrupt a tenant's arrangements. Engagement question. Should landlords step in to pay utilities to protect their interests, or does that create more problems than it solves?
So it wouldn't go on my tax bill, because that's what they do. They don't,
I understand what they do. I didn't ask all that.
I just was protecting myself.
So the water bill's been paid.
Yes, sir.
Do I have a receipt for the amount paid on the water bill?
Yes, sir.
Because when I talked to Landis.
There's been 3 bills.
We have one bill here.
We submitted everything to the court.
Oh, well, we don't have it right now. It's one bill.
$13,1583.
Yes.
We'll just show that to Simon.
Okay. All right, it's okay. It's okay. Okay.
All right, Ms. Lyman, you saw that water bill?
Yes,
Okay. And that was the amount you were gonna set up a payment plan?
yes, that's when I called to set up, they said like an hour and a half or an hour. She had called in, took the bill out of my name and put it in hers and paid it. And then when I emailed about it, she had said, oh, well, you can just pay me now. That's what she said.
Okay, but you're not disputing that that's a water bill you would have had to pay.
Yeah, that's what I would have to pay.
You would have had to pay that 13, yeah, you would have had to pay it anyway. You were just gonna do it a different way with the township.
Yes,
Okay, all right. So you're not disputing the figure.
no, that's the amount that I got billed for. I had a payment plan worked out where I was just gonna pay it over time, not all in full at once.
Where's the email that says that it was going to go to your taxes if it wasn't paid or an arrangement not made?
I can get an email from the town.
I don't, you said there was one.
I have an email from the gentleman. I emailed it to the court. I CC'd the court. It's in the court record.
It doesn't immediately go on your taxes in any event.
They said.
It doesn't immediately go on your taxes. I know how it works.
I didn't work, I didn't want to- So I paid it.
She took it out.
So why'd you take it out of her name?
This is from Cindy Roberts.
Why did you take it out of her name?
Because I had to pay it on the 13th.
But you could have paid it and it stayed in her name. Why'd you take it out of her name?
I put it back in her name, but I just had to pay it.
That isn't that isn't an answer to my question. On the day you went in to pay it, you're telling me that you paid it because you were worried that it was going to go on your taxes.
That's what Cindy.
Okay, that's fine. It doesn't quite work that way, but that's fine. But then the question becomes, why'd you take the water bill out of her name?
Because I wanted to be responsible, so I wouldn't get behind.
But that's not what the lease says, does it?
It says it could be, the lease says it could be paid by me and she reimbursed me. You know, so I was just gonna give her the benefit.
Why was it put in her name in the first place?
I was giving her the option of being able.
Why was it put in her name in the first place?
They told me at the township that it could be put in her name if I wanted it.
Okay, so then it's put into her name. So then it comes down to this date. Why do you change the name on it?
Judge Simpson drills into motive. Changing the name on the water bill wasn't necessary to pay it. That's the judge's point. Utilities accept payment from anyone. When the landlord says she wanted to be responsible, the judge pushes back. Responsibility doesn't require control, and control is exactly what concerns the court here. This exchange reinforces the theme emerging throughout the case. Boundaries. Ownership does not equal unrestricted authority. Once a tenant is in possession, landlords must tread carefully. Audience question: does intention matter here, or only the impact of the action?
On the 13th, they said if the water bill was due, it wasn't paid. I came at like 2 o'clock and they closed it
Why did you change the name?
because I wanted to be responsible for paying the water. I didn't want it to get behind again.
And so you couldn't be responsible without changing the name?
I could put it back to her name.
That's not what I said. You're telling me that you had to change the name so that you could be responsible for it.
So they could send me the bills and I can keep up with it and pay the water bill.
They would send you the bill anyway. You can always go online. You can look it up.
I just was concerned. That's all, sir.
But why was it important for you to change the name?
I thought I needed to be responsible for it. That's all. I just wanted to make sure I got the bill.
You're the homeowner.
Well, maybe I didn't know. I just did the best I could.
No, you did that to harass her.
This is one of the strongest judicial statements so far. Judge Simpson doesn't hedge. He directly characterizes the conduct as harassment. That signals where this is headed. When a judge reaches this conclusion, it's usually after hearing enough to see a pattern. Unnecessary actions, shifting explanations, and disregard for tenant autonomy. This moment validates the counterclaim and reframes the entire case. From here on, the landlord is no longer just a plaintiff seeking rent. She's a party whose conduct is under scrutiny. That changes everything about how damages and offsets will be calculated. Final engagement question for this segment. When a judge openly calls conduct harassment, how much ground does the landlord lose instantly?
Because you could have paid that bill. At any given point, you can go right online and pay that bill.
Well, I thought
They don't care who's it's coming from. If that money is there, it's there.
the lease says that I can pay the water and she would reimburse me. I was just giving her an opportunity to put it in her name.
It was already in her name.
Not from the very beginning, it's in my name. For her kids to take home.
Was it in her name?
Not in May when she moved in. I put it in her.
That was the first month.
I let her.
In June, was it in her name?
No,
July,
no.
August,
I let her put it in August.
September,
Yes.
October.
Going to recollection. I think I took it out of her name in October. So I think I had it in her name 2 months.
Oh, dear goodness, why? Why'd you do that?
I just wanted to,
That was a question.
I was just trying to get it paid, so. Sorry.
You would agree with me, Miss Anderson, that you could pay that bill without changing the name.
Now,
You know, at the time you paid it, you didn't need to change the name, didn't you?
do you want me to change it back, sir?
No, that's not what you knew at the time that you didn't have to change the name.
This exchange matters because Judge Simpson is no longer asking what happened. He's asking what the landlord knew. Knowledge changes intent, and intent changes consequences. When the judge presses on whether the landlord knew she could pay the bill without changing the name, he's testing credibility. The answer lands awkwardly. Hesitation, backtracking, uncertainty. Judges notice that immediately. If you didn't know, say you didn't know. If you did know, own it. What doesn't work is floating in between. From a legal standpoint, this reinforces the interference claim. If the landlord knew there were less intrusive options and still chose the more disruptive one, the court can reasonably infer improper motive. Audience question. In your view, does "I didn't know" still work when the judge believes the answer should have been obvious?
Did you know or did you not know that?
I didn't.
She said you didn't know that.
Okay, all right.
Counsel, you gave me a number at the very beginning of 22,49939, which has been changed to 22,39939
Yes,
as the total rent.
yes,
All right.
not counting escrow.
Right, not counting the escrow.
Right.
When you gave me 33 times 6, you gave me 1,900. So just so that I'm counsel, I'm not double counting. I get for the 6 months of rent, I get 19,800.
Here, Judge Simpson does something extremely important. He recalculates the case out loud. 6 months at $3,300 equals $19,800. That's the anchor number. Everything else, water, late fees, costs, must justify itself on top of that. This is a classic judicial reset. When totals balloon to 22,000 plus, judges often go back to first principles to see where inflation occurred. And once that happens, extra charges come under heavy scrutiny. This also exposes a vulnerability in the plaintiff's claim. If the core rent math is solid but the add-ons are shaky, the final judgment can shrink fast. Engagement question: when courts strip cases down like this, do you think it favors tenants or just fairness overall?